Hey everybody, just give me a moment so I can share this with everyone. If you are here in the comments, take a moment and say hello so I can shout you out. Let me make sure that I am live. So, what are your thoughts? What are your thoughts? Tell me your thoughts in the comment section. Of course, my phone is buzzing, ringing off the hook, but I wanted to have this conversation while I am thinking about it in real time. Alrighty, so my name is Natasha Robinson. I am the creator and curator of Legalese Please. This is an area on digital space where we discuss how to deconstruct, demystify, and decode legal language. And we do it with the framework of liberation. And so I'm glad to see you all digitally. Hello, Daryl. Hello, Poppy. Hi, Pastor Jakes. So I want to talk about what just happened and what this means. So the first thing is that, hey, Sora, how you doing? Is that Derek Chauvin has been found guilty of all charges in the killing of George Floyd. Remember, we learned that this is not called the George Floyd trial because George Floyd cannot be prosecuted for his own murder. But you heard from the jury, that this was a unanimous verdict. It was a verdict that was reached within or a little past 10 hours. I'll talk about that a little bit later. And Derek Chauvin is now convicted of all three charges of second-degree murder, of third-degree murder, and of manslaughter. So what does that mean? There was a term that you heard the judge use, and the judge said PSI. PSI stands for post-sentence investigation. What that means is that in some situations, such as, let's say, capital murder or something like that, some jurors can decide sentencing of the defendant. However, in this case, let me take my glasses off because I have a glare. In this case, it is the judge who will be deciding the ultimate sentence or punishment or consequence of Derek Chauvin. In order for that to occur, what usually happens in most state courts is that there is an investigation report that is done. And that investigation report is, let's say, a life history, if you will, of the accused, of the defendant. And so the person or the department sometimes is pretrial services or probation. Usually what happens is that they go and they interview a lot of people. They interview the defendant's family. They interview the victim's family. They talk with co-workers, former employers. They do psychological evaluations. And sometimes they will interview the defendant, him or herself, depending on if the defendant wishes to make a statement. And then once all of these interviews are analyzed and synthesized, they are then put into a report. And that report goes to the prosecution, it goes to the defense, and it goes to the judge. At that time, if there are any corrections that need to be made, those corrections are made and then incorporated into the PSI, which is called the post-sentence investigation. And that document becomes a part of the official record. That record is then used by parties to argue for the aggravation of a sentence, meaning why Derek Chauvin should be incarcerated for a very long time, up to the max, or factors of mitigation, which is why Derek Chauvin should be punished for the lowest amount possible. And some things that are taken into consideration is whether or not a person is a first-time offender. Is this a crime of violence? Were there any weapons that were used? What is the severity of injury or harm to the victim? And those things are then discussed. Now, the reason why the judge set out the 8 weeks is because this is such a high profile case. It is going to take time to try and get all of those interviews conducted and completed in order for whoever is writing that report to write that report and then it be of the record, part of the court file. Okay, so that's what PSI means. That's what the judge was talking about. As it relates to Derek Chauvin being taken into custody, I don't know what it's called in other places, but in Cook County, it's called being scooped. It means that you are literally taken off the floor, as the sheriffs call it, and that person is taken into custody. Not because they think that the person is even more guilty, but because if they believe that maybe if the person is a flight risk or they just do it as a form of protocol, then they usually take the person who is convicted into custody. Now, sometimes that person is left out on bond, but as you saw with the judge, Derek Chauvin was taken into custody. And so what happens is whatever sentence the judge has for Derek Chauvin, that is the sentence minus any good time or time that he has served in custody. So all of the days that Derek Chauvin may have been in jail awaiting trial, that is subtracted. This time in which he is taken into custody, that is subtracted. And so what he is looking at is 40 years for second degree murder, 25 years for third degree murder, and 10 years for second degree manslaughter. Now, there is some literature that is out there that says that for one of the charges, he is only looking at 12 and a half years in prison because he is a first time offender. All right. So understand that this is me personally now, when I hear justice has been served, I'm like, we shall see. And the reason why I say we shall see is because I also remember when the young man on the west side who was killed by Jason Van Dyke, and he was shot 16 times. And everyone was running around saying justice has been served. And then the judge ended up giving Jason Van Dyke 80 something months, not years, 80 something months, which everyone was like, oh, this is so exciting. Well, if you take 12 months of the year and you divide it into 80, you then realize in real time what he was looking at, Jason Van Dyke. So it was actually 6 years minus the time that he had already served, divided by, whether it's 50%, 85%. So, in the short run, we were looking at Jason Van Dyke to be, well, some of y'all, not me, because I knew that wasn't no time, 80 something months. I'm like, well, hell, 84 months is just 7 years. So, you haven't heard anything about Jason Van Dyke. For all we know, he could be in Aldi shopping. He could be in another state. All right. But we don't know what the judge is going to sentence Derek Chauvin to. But him being taken into custody, that is, really much protocol. So that is what is happening with that. Can Derek Chauvin get 40 years for this unintentional murder, or 25 years or 10 years? Absolutely. Is it going to happen? I don't think so. I don't think so. I don't think that he is going to get the max. Because for all we know, he's a first time offender. Now, that does not mean that it would not be taken into consideration if he has been accused of excessive force in the past. But what the judge will be looking at is different statutory factors, such as the severity of injury and harm to George Floyd, things like, the testimony. There is just a whole statutory framework in Minnesota, as well as in Illinois and other states, that says what the judges are to consider if a person is found guilty. I am answering questions. So if you have any questions, please, please, please type them in the comments, and I will answer them as best as I can. So right now, I'm just going to pause so that I can see what the questions are. And so I would say, now this is Natasha Robinson, Legalese Please. I feel that this is but a moment within a movement. And I say this because think of all of the cases where Black lives have been injured, where they have been snuffed out, where they have been killed, and there has been no video. Think about all of the Black lives and brown lives that have been killed and that have been taken, and there has been video. I say that to say, just because there has been a charge or a holding of accountability, that does not mean that everything's all right, everything's done. Okay? Because I have said repeatedly on this platform, in classes, on panels, that the efficient and effective weapon that anyone in law enforcement can use is not a taser, it's not a gun, it's not a billy club. It's discretion. Discretion can either be a tool or it can be a weapon. And the fact that this is but a page in a litany of killings and of murders, not just of everyday persons like you and I, but persons who are to represent the state, to represent the government. There is more than a problem. And I am here to tell you, as a participant, as an observer of the criminal legal system, I am of the position that the justice system is not broken. It's doing exactly what it was created to do. And so I think that while I would not even caution my reaction as happiness, I'm not happy. I don't know what the word is. I don't know what the word is. Am I glad? I'm not even glad, because you know who's not here to talk on his behalf? George Floyd. And so I just really think that this is one of those things where, as the poem goes, we have miles to go before we sleep. We need to understand what is really at stake and what the victory is. I see a question saying, are these sentences concurrent? Great question. Yes, they are concurrent, meaning that all of the time is going to be served at once. It's not going to be 10 years and then turn around and then to do another 20 or anything like that. They will all run parallel. They will all run together. Okay, so we just have to wait. And yeah, as I said earlier, these are concurrent sentences. These are not consecutive. So I am answering questions. If you have any question, you want to you want to ask. Okay, Sora, so you said they beat his ass in prison. I don't know if you're talking about before he bonded out or now, because I assure you, he is not going to be held in general population. Okay, because even though he is a former police officer, that's not going to happen. So any injuries that he were to receive, I would be highly shocked. I'd be highly shocked if they even still kept him in Minnesota. I don't think that he is going to be anywhere near where this crime occurred. You said, I know I'm late and you may have answered this, but what's the Blakey hearing they are talking about? I don't know what you're talking about. I don't know about the Blakey hearing. Can you share more, Tiff? You're welcome, brother. All right, Pastor Jakes, let's see. Looking at the charges against Chauvin, what's your thoughts about others who've been charged and found not guilty because of overcharging? Great question. You know a lawyer. So here are my thoughts about that. I state that I have never been a prosecutor. So I do not know the ins and outs of what prosecutors think about and what they consider when they levy charges against a defendant. I only have been in the process of responding to what the charges are. That being said, the prosecutors that I know are ones where they look at all of the evidence and then they look to see, okay, this is what the statute says is illegal. What do we believe we are going to be proficient on in winning, or at least presenting evidence when we come to court? I think that when I talk about discretion, I lost my train of thought. Let's go back to the police. When we're talking about discretion, discretion could be a tool or a weapon. The challenge is that, yes, we do want law enforcement officers to have discretion, because there are some times where there may be something that happens on the street and we don't want to have a big case that goes to court when it could have been resolved right there. That's where the relationship comes in. When you're talking about community policing, some police officers, think about if you're stopped with a ticket. They could go through the rigmarole and say, okay, you know what? You got to go to prison. Okay, I was just driving 10 miles over the speed limit. Okay, well, you going to prison. But discretion says, this is not as big a deal. We're going to give you another chance. So discretion, that's great as a tool. When discretion is used as a weapon, you continue to have more cases like what we see, where someone's biases and their racism and their extreme prejudice becomes a weapon, and then becomes weaponizing, if that's a word. So what happens is the discretion is used to an extreme. And so now I get to carry out on you what I think should happen to you, independent of what a court may find. So what I have said to others is that it is not about a police officer being a racist. It is about a racist being a police officer. Derek Chauvin could have drove a cab. He could have been a bus driver. He could have been a magician. But he would just have been a racist ass cab driver, bus driver, magician. Okay? So when we are talking about discretion from the police, that's what I'm talking about. Now, as it relates to discretion from a prosecutor, the prosecutors that I know have tried to bring charges that they know align with the evidence that they purport to present. I think that it pains judges to have evidence presented, but because the charges were too high, then there were elements that were missing that the prosecution needed to prove. I also know that it pains judges when there's undercharging. I want you to think about the case of, now I can't think of her name. I think, is it Rakia Boyd? It's one of these cases where the judge said in the judge's sentence, I'm paraphrasing, I would find you guilty, except what you're charged with is too low. The prosecution could have gone higher. Well, at that time, it's too damn late to have a conversation about, well, judge, what do you think should have been the charge? Because it doesn't work like that. Okay. So whether you are on the side of the justice system needs to be reformed, it needs to be abolished, it needs to be defunded. My position is that the system, however you look at it, it's not broken. It's not broken. Okay, so Pastor Jakes, I answered your question. Well, at least I responded to it. I hope I answered it. Let me know if I did, if I didn't. Let's see. It's the beginning for a new start on how police should conduct themselves when dealing with people of color. I would like to think so. But this is where discretion comes into play. If you were watching any part of the trial or you read any part of the comments afterwards, you heard a great deal talking about policy and training. Well, think about it this way. When Eric Garner was killed on the streets of New York, what was the policy of chokeholds? That you weren't supposed to use them. How did he die? The use of a chokehold. So I say all that to say you can have all of the training in the world, but unless you have succinct and consistent levels of accountability, then what happens is discretion is still the weapon of the day. There is no room for appeal. Yes, there is, Poppy. Yes, there is. There's going to be an appeal. What's going to happen is that the defense attorney is going to, of course, appeal all of these convictions. He is also going to appeal every objection that he made before this verdict. So he may have made an objection about the change of venue, saying there's no way anyone could have been impartial. He's going to object to the fact that the jury should have been sequestered during the trial as opposed to just during deliberation. He's going to object to what Congresswoman Maxine Waters stated when she said, look, we need to hold these people to the fire and we need to be able to go ahead and still call for justice. I'm paraphrasing. And the defense attorney says, okay, well, that was weaponizing speech, to which I'm like, Trump much? Didn't this fool, I'm trying not to cuss, didn't this fool say we gonna stand back and stand by? And did he not say steps from the Capitol, let's go down and do whatever? So if in fact that is true, what's good for the goose is good for the gander. That's just me talking. All right. So there will be an appeal. And the reason why defense attorneys and prosecutors, whatever, they make objections is in the event there is an outcome that happens that they do not agree with, then they are preserving their appellate issues. They're saying, look, this is still valid because we objected to this in real time, and now we are saving those objectionable issues and using those issues to object when we appeal. So there's an appeal. I think what you may be asking is, can he win on appeal? We don't know, because at one point there was an appellate issue and that court decided not to say anything. So we're going to see. How did they find guilty on all three? I thought that typically when you see multiple murder man charges, you pick the one that fits or was proven. You can do all three, Michelle, and I'm going to tell you how. Because each charge is a little bit different. Remember, I said that the most serious involves charges of premeditation or purposeful or intentionality. He was not charged with that. He was charged with reckless mindsets. He was charged with negligent mindsets. And you have to look at the actual statutes to see what the specificity is. So that is why they went with those instead. They mentioned a Blakey hearing, perhaps a legal hearing after this verdict taking place within a few days. Okay, well, while I'm looking at your comments, I'm gonna look up what a Blakey hearing is because I don't know what that is. Let's see. Blakey hearing. Okay, a Blakey hearing. It was a case decided by the Supreme Court in 2004. The case addressed the application of the sentencing guidelines, but the impact was to doubt the validity of all guideline systems. I'm reading because I've never had to deal with that. Let's see. In the Blakey case, the defendant was convicted for the offense of kidnapping. The state law provided for a maximum 10-year sentence. The sentencing guidelines provided for a standard range of just over 4 years. The guidelines provided for general departure if the court found there was a substantial and compelling reason justifying an exceptional sentence. The judge imposed 7.5 years. The Supreme Court found that the process by which the court could impose a more severe sentence violated the defendant's Sixth Amendment right to a jury trial because the judge, rather than the jury, made the findings. The Blakely was significant because the Supreme Court treated the presumptive sentence under the guideline. You don't want to hear all of that. Let's see. From what I am reading, and I have to go back and do my research because, I don't try to talk to anybody about anything unless I know for sure. What it seems like what I'm reading, and all my attorney friends can explain in the comments what it is, but what I think I'm understanding is that if there is a particular range of sentencing and the prosecution is asking for more, there may have to be a hearing to allow that. Okay. Now, as I said, I'm just reading on the fly. If I find that to be different, I'm going to come back and post it and tell you what it is. Okay. Let's see. Just going through the Blakely hearing. Let me go back up. The Blakely hearing, defendant Sixth Amendment right to jury to provide. Yes, I found that. Thank you. So what it seems like is maybe there is a range and the prosecution is going to be saying to hell with that range. We're going to ask for more time. And in order for that to be approved, there has to be a hearing for the judge to consider that. All right. Yes, Rakia boy, I answered it. Okay, great. I'm glad I did answer your question. Let's see. The jury was sequestered. So how in the hell did they hear what Water said? Well, now, I've done a few jury trials in my day, and you would be surprised at, and I put the emphasis on the ed, you would be surprised at what the jury knows. Okay, and I'm going to leave it like that so that I don't indict the guilty. But understand, in order for it to be a true sequestering, if that's a word, there has to be no communication whatsoever. That means cell phones are taken. That means that they are watched by a sheriff 24 hours around the clock, and there is to be no outside communication. I don't know if that's the case, but even if they did not hear, and this is what I said to Osoro earlier, even if the jury did not hear what Maxine Waters said or what the judge said about what Maxine Waters said, I believe that the judge was improper in his commentary saying, yeah, you may have rights, you may have grounds to an appeal. No. That's not what you're supposed to be doing. That's not what you're supposed to be doing. Okay. I think I have covered everyone's conversations. I do see someone talking. I don't know who that is, but there is a conversation. So I tell you who I know it's not. It's not George Floyd's family, and it is not the defense. Okay, so it's probably the prosecution. I have it on mute because I'm talking to you all. Okay, what's my Cash App? Oh, snap. Let's see, because I already have it typed out, but I don't usually post this. And where did I? That's funny because it's not down here. All right, so my Cash App, legalese. No, I'll do you one better. Let's see. Legalese, please. That's Cash App, and then let me put Zelle, okay, which is the same thing, but it's an email address. legalese@gmail.com. Okay, so this is the Cash App. Legalese, please. If you say I don't play like that, then this is Zelle and PayPal. Okay. I'm going to let that do what it do. But I really back to the comments to make sure I have not skipped anyone. Hey, Sora, Cheryl Jackson, they was requested yesterday to close the argument, spoke out over the week. Yes, that I do know. Oh, the Attorney General for Minnesota, that's who's talking. Okay, Keith Ellison. Okay, thank you. because I'm, like I said, it's on, but I'm not paying attention. Okay. I'm sorry, because someone walked up to my door and I was like, who is that? It's the male person. Okay. All righty. So yeah, so that's all that I have. I really just wanted to come on and kind of say, where we're going now. I've been on half an hour, so that's way too long. But I did want to come on and just kind of put some context on the content of the finding of guilty, so that we know that yes, this finding of guilty is definitely a step. I'm not undermining that. But we still need to find out what the sentence is going to be. And we need to make sure that there are not going to be any more George Floyds. And in this country, in this climate, as long as discretion becomes a weapon and not a tool, this will not be the last. Okay? In time and between time, take care of yourselves. Make sure that you are engaging in self-care, because we do not here at Legalese Please celebrate in the commodification of Black pain, Black injury, Black harm. I have created this platform for us to be informed, but I will not continue to feast upon what is being served to us, because people love watching pain. Okay. And so I don't do that. So I would suggest that you do guard your heart, guard your mind, guard your ears, and make sure that whatever information that comes your way, you have the right not to digest it. Just because it's served doesn't mean it has to be consumed. Okay, so remember that. And if there are any updates, I will be sure to let you know. I do know that Bishop Vanessa Brown has asked me to be on Beyond the Gatekeepers tomorrow night at 7 p.m. And I will be on with some legal professionals, and I will be on with Bishop Yvette Flunder and Bishop Carlton Pearson. So I will be sharing that from my page. And we didn't know that the verdict was going to come out. But that's what we're going to be talking about. And I'm going to be one of the panelists. So I solicit your thoughts and your prayers, because you know how I do over here in Legalese Please. I speak the language that the Lord speaks, which is not just the truth, but a language that is, it is what it is. So thank you. Thank you to all who have been here. As I said, I do this as my service to the community. It's my calling. Hey, Sister Gail, 7 p.m. Central Standard Time, or Central Daylight Time. It's in the evening. And I will be here, and we're going to have a good conversation. Okay? So just pray for me, because I'm really nervous, but we're just going to make it do what it do. All right. You all be great. I have to go pick up my boss and attend a board meeting. So you all have a good evening. Please be safe. All right. Take care.